Today was the day when the Massachusetts Supreme Court heard oral argument on Karen Reed's appeal based on double jeopardy. So we live streamed it. And if you're able to join the live stream, that's great. I was able to give some analysis for that. But now we're going to recap it and we're going to give you some more analysis and some more of my thoughts on what happened during that oral argument and some of the questions that the justices asked, some of the answers that Marty gave, and maybe you could have given different answers. So we're going to be looking at Marty Weinberg, specifically his performance, going through his oral argument, some of the questions that were asked of him, and we're going to be stopping right then. If you want me to also do the Commonwealth's oral argument and talk about that, we can also do that. Definitely let me know in the comments if you'd like me to do that. I do want to give a shout out to two specific entities. Number one, the sponsor of this video, the Suit Depot, which is a wonderful store which sells very high quality suits and apparel. I personally shop there, and it's just great stuff for very reasonable prices. And now my listeners get a special 10% off. So when you're checking out of the Suit Depot online, which the link is in the description, you can just type in Brother Counsel, all lowercase and no spaces in the coupon box, and you will get 10% off of your order. Number two, I'd like to give a shout out to the Young Jerks because I'm using their video that they live streamed the event. The oral argument. There are some other channels that also live stream it, but their recording wasn't as good. So I'm going to be using Young Jerk. So I appreciate being able to use them, and a shout out to them. And definitely you can go subscribe to Young Jerks and they have a lot of Karen Reed stuff as well. So I'm using their live stream, of course, adding my commentary, which is obviously allowed and legal. So here we go. Let's pull it up and we'll start with Marty Weinberg's arguments. Here we go.
SJC 13663, Commonwealth versus Karen Reed.
Attorney Weinberg.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed.
Now, before he starts his oral argument, I would like to just let you know how I personally would approach this. Like I've said before, if you've been following me, we've talked about all the issues that they're appealing. But really, there's three discrete issues that they are arguing. Number one, they're arguing that really the jury acquitted Karen Reed. Let's just call the jurors back and let's get them together and they'll all remind us or tell us really what their verdict was with respect to charges 1 and charges 3. And let's just acquit Karen Reed of charges 1 and charges 3. That's their first request. The second request is that the mistrial that was declared was inappropriate. You have to follow certain rules as the judge before you declare a mistrial. Number one is that, was there any opportunity for the defense to object to the mistrial being declared? If there's no opportunity, that means that the defense did not consent to the mistrial being declared. So that's issue number two. Was there consent by the defense to for this mistrial? That's issue number two. Number three, even if the defense did not consent, was not given the opportunity to object, let's say, the next question is, was there manifest necessity and to declare a mistrial? And if there was manifest necessity to declare a mistrial, there are certain rules that the judge has to follow in order to declare a mistrial based on manifest necessity. So really, the way that I look at this is that there's three discrete issues, and I would break that up into the three issues. Your Honors, there's three issues that we're bringing forth in front of you today. Number one, Karen Reed was acquitted. Number two, the defense did not have opportunity to object. Number three, the requirements that the judge was supposed to follow in order to find manifest necessity was not followed. That's how I would break it up to make sure that we don't convolute the law as it is in respect to the acquittal, the opportunity to object, and the manifest necessity, because we find that it's very easy to get convoluted, and we're going to find that that actually occurs during this oral argument. So that's how I would have done it, just for simplicity purposes, and also just to make sure that the justices are following me with respect to each individual argument. And as I've said before, the argument for acquittal is the weakest one, and therefore my main focus would be the fact that there's no opportunity to object, and your strongest argument is that the requirements for a judge to follow, those rules to follow in order to find a mistrial was declared because of manifest necessity, that's the strongest argument that Judge Cannoni did not follow those two rules. There's two rules. Number one, the counsel has to be given full opportunity to be heard before the mistrial is declared. That obviously was not done. Number two is that there has to be careful consideration given to alternatives to a mistrial. That also very clearly wasn't done. So in order of strength of your arguments is manifest necessity. That's the strongest argument you have for Karen Reed. Number two, not opportunity to object, because there wasn't that much opportunity. There was still some opportunity, but not a lot. So that's your next argument. And then the weakest argument is the acquittal. So that's exactly the order of the strength of the arguments. That's how much time you want to devote to each one. But again, we're going to see how Marty does it, and you'll right away see what the problem is.
Today's appeal goes to the core issues regarding double jeopardy protections that safeguard defendants, in this case, Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent. And we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
So the first question that the judge wants to know, the justice wants to know, is how do you know that the jurors that contacted the DA's office are different jurors than the ones that contacted you? Maybe you're only talking with those same few jurors. Maybe they're all the same jurors. Now, he never said that they're not. He just said that we have 4, possibly 5, and that should open up the inquiry. So I think this is just a misunderstanding there.
I don't have a basis to.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 or could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
So that was just a point of clarification.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding.
Mr. Weinberg, you jump all the way to acquittal, correct?
So here, he jumps right into the justice jumps right in and says, Mr. Weinberg, you're asking for an acquittal here. That's what you're arguing. One of your arguments, again, this is the weakest argument in my opinion. You're arguing that she should be acquitted, right? Let's call the jurors back and let's acquit her, right? So that's essentially where he's leading him, and he's going to I have to answer yes.
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to.
So this is the justice is reading straight out of Rule 27. The first rule there says directly about what the justice is about to say, which means that it has to be recorded and it has to be in open court in order for you to have a verdict.
To be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
So very strong question. Tell us, how is this an acquittal? There was no verdict read in open court. That's exactly what the rule says. 27, it has to be filed with the court. Both of those things weren't done. So how are you telling me that really Karen Reed was acquitted already?
It's less a matter of labels. I could call it, Judge, a unanimous
Well, you
decision.
cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error. That case is an opposite to what the situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
Well, that's a double jeopardy claim.
So he's saying, you're right. I'm not asking the Supreme Court to say that there was an absolute acquittal in this case, and then that's it. We're done. What I'm asking for is to bring the jurors back and then show us that there actually was an acquittal. Testify to that. Have an evidentiary hearing, bring the jurors back, and then they will say, yes, we did acquit her, and now that she's acquitted, so now double jeopardy will attach. That's what they're essentially asking for with the acquittal
Claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc.
So this is a very strong question, which we spoke about a number of times before, is that the only cases that you can find that allow the jury to be brought back, to be asked certain questions, is only when there was racial bias or extraneous influences, jury tampering, things like that. But never did we find any sort of case that says that you can bring the jury back because they decided that really their verdict was something else than what they told the judge. So that you don't find any sort of cases for that. So again, the Marty Weinberg, they're asking him, you're asking for us to order that the jurors come back. Is there any sort of authority which allows us to do that? The only cases that we found are cases that have racial bias injected into the deliberations or extraneous influences.
Here, do you want us to carve out a new exception to that rule?
So he's asking, should we carve out a new exception? Should this be a new precedent? And I told you before, anytime you're asking the Massachusetts Supreme Court or any Supreme Court to make a new rule, you have a very hard job convincing them to do that. They don't like to make new rule. So that's what he's asking. Are you asking us to make a new rule here that we should also now allow jurors to come back when they decide afterwards that really it was they acquitted somebody as opposed to convicting them?
Rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing.
So he's saying that, basically he's saying, yes, I want you to extend all of the previous case law, which says that you can bring jurors back for questioning when it has to do with racial bias or extraneous influences like jury tampering. I want you to extend that to situations where the jurors afterwards get together and say, well, really, our verdict was something else than what we reported.
Flexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
So again, that was extraneous influence. So again, it's a different case, but still he's arguing that we should extend that.
Fiddler caution to not inquire into to not to intrude into the sanctity of the deliberative process as well.
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
So now he's saying, well, that case that you just cited, Fiddler, that case actually also tells us that we have to be very careful not to inquire into the deliberative process, what's going on in the jury deliberation room. You're not allowed to do that. You are allowed to ask, about jury tampering. Did anybody say anything to you that's not, did you look at any evidence that wasn't included in the presentation of evidence? Did any sort of evidence get to you some other way? That you're allowed to do, because that has nothing to do with the deliberative process. But Fiddler also cautions that you cannot ask about the deliberative process. And it seems that you're asking that in this specific situation, you'd be asking the jurors to come back and we'd be asking them specifically about their deliberative process. What were you thinking about count 2? What were you thinking about count 1? What were you thinking about count 3? Now, his response is going to be, I think, a fair response, which is a good response. And that is that, no, we're not asking them for the deliberative process. We're not asking them for their thought process. We're just asking them for their verdict, what their verdict was, not their deliberative process. And that's going to be his response, which is a decent response. But again, the ultimate issue here is you're asking us to extend the case law in Massachusetts now. You're asking us to make new precedent and extend it to situations where jurors decide that their verdict was not really recorded properly.
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count 1? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry,
You
Judge.
seek to impeach the written communication of the foreperson, correct?
I wouldn't, I would say that it would, that
So he's saying, really, what you're asking the jurors to do really is to impeach, meaning that note that the juror wrote that they're hung on all the charges. You really want to impeach that specific juror and say that, no, they really were not hung on all the charges. So that's what he's asking.
the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. But count 2 by itself, read vertically, had multiple charges. Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred.
So they're arguing that there's ambiguity in that note, which everybody's already heard about. Is the charges all the charges? Is the charges just the charges in count 2? And like I've said before, not the greatest argument, but that's what he is arguing.
And not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration.
And now he's kind of shifting his argument away from the letter, because he probably realizes that note and this argument is not the greatest argument. And he's moving into the manifest necessity. He's moving into the failure of opportunity to be heard. He's kind of trying to move the conversation there, because I think he realizes that that's a stronger argument for himself.
Of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
Really, you've got an exhausted jury writing this very eloquent message saying, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words.
But again, there's no inkling of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is it an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
So now he's coming back to you're arguing that there's no opportunity to be heard, right? Well, what about when they were discussing scheduling? After the jury was sent back, the judge can only dismiss the jury, even though you're right. Maybe there was not opportunity then, but then right after that, they were discussing the scheduling. And right then, why didn't anybody make an objection there? Isn't there plenty of opportunity then to be heard and make your objection that you object to the mistrial? Why not then?
Once the judge discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection, it was futile. It
What
was
about,
unnecessary.
what about the case?
So now he's saying, well, once the judge dismisses the jury, well, then there's no point anymore of making an objection. That would have been futile anyway. So there's no point. So then why would they make an objection? Now, again, this really is against the case of Fuentes. Fuentes says that there was an objection that was made later, which was found to be a fine objection and a valid objection. It wasn't futile. But that's something that the state and the Commonwealth can argue, which they didn't, by the way, because they didn't have me whispering in their ear. But that could have been an argument that could be made that, no, that's not futile at all. And now this justice actually is going to cite a different case, which says that, no, you could, just because the judge dismisses the jury, they can still call the jury back.
Case of Commonwealth versus Enid Brown, where the jury was sent, the jury
Commonwealth versus Eden Brown. He's going to explain what that case says.
goofed, essentially. There's a miscommunication between the clerk and, you know, the case. The jury was discharged, sent into the jury room, and then we said it wasn't ever to bring the jury back after discharge to clarify the verdict.
And
So he's saying, you see that we could bring the jury back to clarify. So if the attorneys would make some sort of record or some sort of objection after Judge Cannoni dismissed the jurors, and the attorneys would have jumped up and said, you know, Your Honor, we object to this mistrial for whatever reasons, she could have still called the jury back, and that would have been fine, as this case says.
had the jurors that assigned or that made these representations starting the very day after the announcement of the mistrial, if they had told the
But
judge,
I guess the point I'm asking Mr. Weinberg is, there was a
It seemed like he wasn't really responding to this. This is why the justice cut back in and says, I'm not sure if you're understanding my question.
time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference in time and others. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
So again, he's bringing up the same question that he started off with. After they dismiss the jury's still there. The attorneys could have objected.
it was an opportunity, but not a responsibility. The law in this case, starting
So now he's moving on to a different thing. He's saying, okay, I'm going to acknowledge that was an opportunity. Before, his argument was that it was futile, would have been futile. Now he's saying, well, you're right. There would have been an opportunity to object there. It's not futile. So he's taking back that argument, but he's saying it's not a responsibility. Now, for this, really, the case law is directly against Mr. Weinberg. The case law says specifically, if failure to object means consent. But still, he's going to make the argument, at least, to say that it was an opportunity, but not a responsibility. So the fact that they didn't is not going to be held against them. And again, there's no case law that he's citing here. This is just his own thinking on his feet, trying to come up with an argument.
39 years ago was Stewart, places the heavy burden on the Commonwealth.
So now he's going to argue, well, it's really not our responsibility. It's the Commonwealth's responsibility to look at other options for manifest necessity. And again, it's not the Commonwealth's responsibility to object for the defense, which the case law, again, is clear that if you don't object, then it's consent for the defense. So again, he's just trying to push everything away from this opportunity that they had to object after the judge dismissed the jury and sent them back to the jury room. So now he's going to argue that it's really all the Commonwealth, the burden's on the Commonwealth.
Which wants to re-prosecute a citizen in the face of the decision of the first jury to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is
Okay, so now he's going back to, you said that there's three other alternatives. Let's go back to that discussion because he's not really, I think he sees he's not really going to get anywhere with this. So he says, okay, let's go back to that.
the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity.
And these are just chats on the Young Jerks channel. So all credit to them.
To be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question. It has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were two
Why-
ways to interpret the note.
Wouldn't,
And again, these comments that are coming up on the bottom of your screen, these are from the Young Jerks channel. And I'm just going to let them pass without having any comment about them. But even though I may have some thoughts about them, but I'm just going to leave them for now.
don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes 2 previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes,
I-
and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks.
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note and the third note
Yes,
that would indicate any less of an impasse between the first, second, and third notes.
yes, what happened?
And this is a rhetorical question. She's basically just saying nothing happened between the second and third note, which would lend you to suggest that they're less at an impasse by the third note than they were by the second note. If the second note was clear that they're at an impasse for all the charges, so then nothing really changed by the third note. That's really what she's just citing, but she's asking a rhetorical question.
Is that
I'm just looking for a record site.
the record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all 3 notes are ambiguous. The defense.
That was not the argument you made below.
So now he's arguing, well, all 3 notes were ambiguous. Well, is that true? Is that the argument that you made, or is it just that the third note was ambiguous? And that's just she's calling him out on this. He's saying, wait, you didn't make that argument at the lower level.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there
They
was
asked-
no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was an
time,
ambiguity.
not at the motion.
So now she's saying, no, I don't mean the motion that you filed afterwards. I mean, at the time that these notes were read, there was any sort of suggestion or argument by defense counsel that these notes were ambiguous as to what they were at an impasse about. And that obviously he's going to have to concede on.
To dismiss at the time.
They had no opportunity at the time.
First
to-
note, was there an argument?
And now he's saying, well, they didn't have an opportunity. And then she's going to say, well, you did have opportunity after the first note and the second note. So don't argue that they didn't have an opportunity after the first and second note.
Made concerning ambiguity in response to the first note reporting impasse.
No, there was a request.
Was there
for
any
TUI.
ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing?
And then he said, well, I'm only concentrating on the third note. So the justice is saying, well, why should we only think about the third note? Let's think about the totality of the circumstances. Let's think about everything altogether, which seems to suggest that the jury was hung on everything.
any legal authority? Why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the 3 alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The
What,
reporter's notes.
at the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said
Nothing.
they were at an impasse, and the court has an obligation to carefully consider all
Now you hear that she said that the court has an obligation to carefully consider all alternatives, which is true. That is what the case law says before declaring a mistrial based on manifest necessity.
alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez, and she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
So she's saying that, well, all of this information that came in from the first note, the second note, the third note, well, that also means that she carefully considered all the alternatives. And the response really should be, well, Your Honor, that's simply just not enough. You have to carefully consider the alternatives on the record. And there also has to be opportunity for counsel to be heard, which wasn't done. So even if she may have in the back of her mind considered some alternatives, but number one, it has to be done on the record. Number two, that counsel has to be given opportunity to be heard. But we'll see if Mr. Weimer responds that way.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your rule would be that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a
So now she's asking him, is your rule that the judge must do this, must make an inquiry as to different verdicts, maybe charge 1, charge 2, charge 3? Is that what you're suggesting? And remember, initially, just a few minutes ago, he said that the rule in 27B, which he actually quoted correctly, is that the judge may make an inquiry into separate verdicts. So now she's asking, are you suggesting that we change the rule? And anytime that they ask you, do you want to change the rule? Your answer always has to be no, because that's a no-no. So here, the correct response would be, no, Your Honor, I'm not saying that must be followed, but because it's in possibility, because it's an alternative that could be explored, she had business exploring that on the record. And she can say, you know what, I've explored this, I've given it careful consideration about asking for separate counts, and I'm choosing not to do that. That's fine also, Your Honor. So that's really, I think, what the correct response to this question should be.
multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
So now he's kind of arguing that, yeah, and he's trying to argue that that's what the rule stands for, which is just not a great argument.
I thought that it was a may, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
In the ordinary case, the four
So he's actually making the argument that really that's what the rules require, must, which again, not a winner argument.
person will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples. But 27B preempts that in terms of the importance of a mistrial order.
In your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence.
That doesn't really answer the question. He's kind of, again, being put in a very difficult position because he kind of made an argument that, yes, I am saying that the judges must make this inquiry, even though the rule states clearly may. And yeah, the reporter's notes say must, but it's not exactly how he's presenting it. But when the rule itself says may, then that's the rule. And he's putting himself in a very poor position by saying that really the rules require her to make an inquiry onto separate verdicts. So he's trying to, again, move it away back to manifest necessity being given the opportunity to be heard.
As far as the deliberations go and the notes, that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of two interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-TUI of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter of
of these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple,
But
they had 3
so
different.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2.
I think they're
There was
speaking past each other
supplemental
right now, by the way.
instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could.
So this is going to be a tough question. And this takes experience to know how to answer this following question. The question he is going to be asking Marty at this point is, the judge in her opinion said that she cannot ask about partial verdicts because it would be coercive. So he's going to ask Marty Weinberg, what do you think about that? Is that true or is that not true? And it takes experience how to be able to respectfully disagree with the Judge Cannoni in this situation, which she said in her opinion that she's not allowed to ask. And the correct response would be something along the lines, Your Honors, it just respectfully, Judge Cannoni just misstated the law. As we can plainly see in 27B, that option is there. She is not precluded from asking about different verdicts. It's definitely an option. It says straight out in the rule. So if I have to go with the rule of 27B or what Judge Cannoni put in her opinion, I would have to argue to the court that rule of criminal procedure 27B is the authority that we should follow here. And Judge Cannoni just simply made a little mistake here. But let's see how Marty deals with this.
Without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on
Well,
that.
my thought process, one is that this court has the option of essentially informing the court what questions could be asked. And two,
But
if we're
again,
going to
they're going
delegate.
to require follow-up questions. And unlike extraneous influences, where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect, this is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations inevitably?
I think you can ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask.
So he's just asking, like, how would we actually ask the question without going into the deliberative process? And he's just saying simply, yeah, just say, what's your verdict? I mean, what was your verdict? Without telling us about how you got there or why you got there. Just tell us what your verdict was on charge 1, 2, and 3. So that's pretty simple answer.
Ask you the following questions. One, did you take a vote on count one? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that gonna, the jury can change its mind, right?
Could, but there's no way.
But isn't that gonna result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor,
Well,
wait, I
they
didn't
also
agree.
don't write in saying we agree with the other 5 or anything to that effect. They're silent, as their deliberations are supposed to be silent, right? See?
But it's an almost unprecedented meeting of a burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what juror D says. We went to the bus and says, no one's ever going to know that we
But
voted to acquit.
isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's the
Again, in Bluford, that was actually a different situation. That's where the jury was sent back to the jury room and then came back, and their votes could have changed while they're in the jury room. Here, the question here is they've already done deliberations. They're not deliberating anymore. We're not sending them more for any more deliberations. They're in front of us right now. They're going to get dismissed unless they answer these questions. They're going to get dismissed. They just have to answer these questions. One of the questions is, what was your verdict on charge 1, 2, and 3? We're not deliberating anymore. So the question really, I think, is not the greatest question.
your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time.
So, the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. if you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count two that might inform a juror's change of position on count one and three.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there this communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with
Right,
an
but when
external
it's an
source.
extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And again, they're going back to the deliberative process, which again, I don't think it goes into any of the deliberative process. So, Your Honor, we're not going into the deliberative process. It's just simply, what was your vote on count two? Are you hung on count two? I'm sorry, were you hung on count one and count three or not? It's not going into the deliberative process. I keep having trouble saying that, but they keep coming back to that. And I'm not sure why.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not guilty?
juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count two. We were not yet done.
And that would reflect two
It's a
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannone, if conducted, that was my vote. It was not guilty.
It
We never
seem-
reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the
Which is why there's so much time here and effort wasted on post-juror inquiry. Like I said, this is the weakest part of the argument. And I think your strongest argument is more about the fact that the mistrial was declared inappropriately. To ask to bring the jurors back and ask them these questions, the deliberative process, this and that and the other thing, that's not going to go too far. Just the fact that there is a possibility to ask for separate verdicts, that's straight out in the rules. You don't have to figure out different ways to, how this is actually going to work out, because the rule says that it's a possibility. So then you can just rely on the rule that should be an alternative that the judge considered. But a lot of this time is wasted because they keep asking and pushing to bring the jurors back and ask them questions in order to get an acquittal. So you're going for the home run, which is on very shaky ground, instead of just concentrating on your strongest arguments, which is the fact that the mistrial was declared inappropriately.
jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions. And we have a long line of jurisprudence that says we presume that the jury follows the instructions.
And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The
That's
Capen
not
case.
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity.
Okay, before you,
No, he's trying to move back to manifest necessity because that is a stronger argument. To bring the jurors back is just not a winning argument in this specific scenario.
shift back to that, what's the best case, best federal case? Because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? What's if we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus
That's
State that the amici
That's a
brief
state court
brought us
case, right?
to. They read the
It's a state
newspaper.
court case, right?
It is.
Any federal?
He asked for a federal case. Don't tell me a state court case. Tell me a federal case. This is a federal issue, constitutional issue, double jeopardy. You want to bring the jury back. What case should we read that once we read that case, then we'll see, oh, this is what Mr. Weinberg was talking about. This is why we should grant that we should call the jurors back in the Karen Reed case. Give me that case that's just going to be the aha. This is what Mr. Weinberg was arguing. Just give us that case. And obviously he's going to have to go back to the cases, which is talk about racial bias. And then he's asking them to extend that.
Federal cases, because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
this court has a long history of
Yeah,
applying
but we don't
federal
have any
constitution.
cases except extraneous influence cases. I'm just looking, again, your chance.
You
The
do
best
have-
case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Right. So the McCallum case, that was the McCallum case, which talks about racial bias. So extraneous influences, really not much to do with this scenario in front of us with the Karen Reed case, but that's what he wants them to extend. So this is kind of just putting him on the spot with this specific inquiry, which again, so much time being wasted on this request to bring the jurors back. And it's the weakest argument on behalf of Karen Reed.
Again, that's extraneous influence. That's different.
It's internal. I think it's closer to the core of 606B.
No federal case we can turn
There's-
to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by the
So now he's saying, well, the prosecution, the Commonwealth didn't bring up a case to the contrary. You're right, but this is your appeal. Your appeal. You want us to do something. You've got to be the one to bring the authority.
this jury, it's not going to open the floodgates for post voir dire.
Well,
This is
actually,
a-
that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
It's
So exactly. I mean, this is the point that I brought out in a number of my videos. If you're going to extend it, exactly what you're asking us to do, Mr. Weinberg, you want us to extend this to bring the jurors back, even when the jurors comes back and they say, our verdict really was to acquit and not to convict. Well, what's the limiting principle? When do we not do that? So if you have one juror that pipes up 3 months later and says, oh, by the way, that really the verdict was not guilty onto some of the charges, then we should bring all the jurors back 3 months later. Like, what are the guidelines? How do we draw the line with your request? So this is a very, very strong question, because once you move beyond racial bias, jury tampering, extraneous influences, improper evidence that the jury shouldn't have seen, once you move past that, then where do we draw the line?
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room.
So now he's just saying, well, I guess we should draw the line that if a juror just has second thoughts and really just wants to take back their verdict. But what happens if you have a juror that says, really, that wasn't my verdict? I never agreed to this. And they wrote it down without my consent or something.
These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty. And
So the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the steward.
So that's actually a very strong question. Is it abuse of discretion for her to not order the jurors come back? That's what our determination is. Is it an abuse of discretion to not come back, to not order the jurors come back? You want us to extend this rule to bring the jurors back, and you're saying that Judge Cannoni abused her discretion by not calling the jurors back. You think that your argument to extend this, that Judge Cannoni should have extended it beyond racial bias, that's an abuse of discretion that she did not extend it? That's a very strong question. He's not going to really have a great answer to this.
Case says,
which is why we keep coming back to the same thing. Bringing the jurors back is just a failing argument. It's never going to work, and it's just a waste of time.
the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning, did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity.
So again, he's moving back to manifest necessity. He keeps moving back to manifest necessity. Anytime that the water gets hot, you want to move back to your stronger arguments, and that's what he's doing. So it didn't really answer the question.
Simply wasn't followed in this case. It wasn't followed the basic rules. It's Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B or would have asked the judge to ask the jury whether.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think.
So now they're actually going to talk about the opportunity to object. And this is going to be a very strong question. You got very experienced attorneys there, and they know what's coming down. So here we go.
Potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table? Is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
Let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised They weren't given an opportunity. They hear a door open, the jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
Wait,
So
the judge said they're at an impasse, bringing the jury?
bring in the jury and you can actually hear a door open.
Okay,
So
and you
when-
have 30 seconds to object?
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
So again, they're arguing. Everybody knows what's about to happen. The judge said the jury's in an impasse. Every lawyer worth their salt knows that after Tweed Rodriguez and after the jury sends out another note that they're at an impasse, they know very well that a mistrial is coming down. And now the judge quickly said, okay, the jury's at an impasse, bring the jury in, and you hear a door open, you have 30 seconds. Well, if you're a competent lawyer, shouldn't you say, Your Honor, may I see you at sidebar? Your Honor, may I make a record before you bring the jury out? There was some opportunity to be heard, and that's what they're pushing back right now against Mr. Marty Weinberg.
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were in an impasse, bring the jury in. Yes, that was possible, but to
What was possible?
to ask to go to the bench, but
Yes.
this
And
court
did that
has-
happen?
No, but neither did it happen that the prosecutor.
So now he pushes it again onto the prosecutor. So anytime that he gets too much in hot water, he pushes it to manifest necessity, and then he pushes it to the prosecutor. Well, the prosecutor didn't need to do it. Yeah, but you're the one you want to object. You want to show that this is not with your consent. That's what the case law requires, that this is not with your consent. If it's not with your consent, the case law requires for you to make an objection, not for the Commonwealth to make an objection for you. It's your duty to object.
Who this court says has a heavy burden because they're the sovereign. They want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial.
Now that's true. You don't need the consent to declare a mistrial based on manifest necessity. Now, if you're Marty Weinberg, this is exactly what you want the judge to do. You want this justice to ask you this question. You know why? Because your strongest argument is the fact that the judge did not follow the requirements in order to declare a mistrial based on manifest necessity. This is absolutely true. Judge Cannoni did not give full opportunity for counsel to be heard. This is what she's required to do under manifest necessity. And number two is that she did not give careful consideration to alternatives. So this is a question. This is a slow pitch over the center of home plate for Marty Weinberg. It should be.
She needs to determine that there was manifest necessity for a mistrial, correct?
After a careful consideration of all alternatives and after giving.
So
the
that may
defense-
explain why perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a
Mr.
verdict.
Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than declare mistrial?
Well, the statute itself,
So here, is there any case that you found that actually something different happens other than a mistrial? And the response to this could be, Your Honor, I didn't find any specific case that played out this scenario, but I do have a number of cases that tells the judge what to do if they want to declare a mistrial. So that you have to follow the rules. The fact that the judge, that all the judges in the past and all the case law followed the rules and nevertheless still declared a mistrial, that's okay. There's nothing wrong with that. But still, all the cases and the statutes and the rules of criminal procedure say that you have to follow a certain rules before you declare a mistrial, and that wasn't done.
Says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes.
Right, and in the face of that,
In the
you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was.
Again,
And
at
in
July 1.
the statutes, again, is a may, correct?
The statute says 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on two counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
Okay, so he ended pretty strong, which is good. You want to end strong. But I still want to come back to what eventually is really going to happen in this case. And again, like I said, the strongest argument here is manifest necessity. Very clearly, she did not follow the rules when it comes to manifest necessity. The problem here is that there was an opportunity to object. And you only get to manifest necessity, you only analyze this scenario under manifest necessity if there wasn't consent. And since there was consent, like I've been saying all along, even though it was only a very small amount of time, but experienced lawyers like this should have seen that a mistrial was coming down, and therefore they should have, if they had any sort of issue with it, object either within those few seconds, object after she dismissed the jury, like one of the justices suggested, and therefore, most likely, if you're a betting person, you should bet that this is going to get denied by the Supreme Court, and there's not going to be any juror inquiry, and there's not going to be double jeopardy. She's going to be tried for all three charges again, if the Commonwealth wants to. Now, I want to make very clear, even though I'm very strong because I've actually researched all the law on this, and I actually did a deep dive in all of the case law on this, and I see exactly what the law in Massachusetts is with respect to double jeopardy. I still feel that Karen Reed should have been acquitted. There definitely was not enough evidence to prove beyond a reasonable doubt that she committed this crime. No question about that. But this is a separate issue. This is a separate issue of double jeopardy. Does double jeopardy work here or not? So if you're able to look at this without your emotions involved and just look at it reasonably and look at what the case law says, in this specific appeal, Karen Reed should lose this appeal. And I feel bad, like I've said before, this was a losing appeal from the get-go. It was a waste of money. It was a waste of time. And now we're just going to wait for this opinion to come down, which most likely, according to the law in Massachusetts, is going to come down that there's no double jeopardy here. They're not going to call the jurors back, and that's going to be the end of this issue. And then we're just going to look forward to this next trial, that the retrial of Karen Reed. Now, just to give you some more information, the retrial of Karen Reed was supposed to happen on January 27th, I think it was, 2015. However, there was a joint motion filed by the state, the Commonwealth, as well as the defense to adjourn the date to April sometime. So they want this trial adjourned to April, the retrial. And a big reason for that is because the Commonwealth has retained, or is seeking to retain, some biomechanical engineers who will be experts to contradict, seemingly, the ARCA experts, which said very clearly, their opinion was that it is inconsistent. The damages to the vehicle and the injuries to John O'Keefe are inconsistent with him being hit by that car. And that should be the end of it. That was the end of it. And I don't know why some jurors felt that that wasn't enough of reasonable doubt to say that Karen Reed didn't hit him with the car. So that's the big question in my mind, how jurors can, after hearing those two extremely qualified experts testify that the science does not support Karen Reed hitting him with the car, how that doesn't equal at least reasonable doubt. Nevertheless, the state now is trying to seek out and hire some experts, biomechanical experts, who are going to contradict these ARCA experts. So now what are we going to be left with? We're going to be left with, if the state actually accomplishes this goal and they can actually get some biomechanical engineer to somehow explain how the injuries of his arm, those bite marks, essentially equal him being hit by a car. So even if they're able to get these experts to say that, and to even assume that they're somewhat as qualified as these ARCA experts, so then what do you have? You have 50-50. You have the experts canceling out each other. How is that not reasonable doubt? There's still reasonable doubt screaming all over the place. So, I mean, I'm sure the trial seems like it's going to be different. They hired a new prosecutor to get it, but I think that any juror, after hearing those experts, those ARCA experts testify, even if the state has experts, unless those experts are so much more qualified than the ARCA experts and can explain in detail why the ARCA experts are wrong, which I think is going to be very difficult to do, then this trial should still be left as an acquittal. So that's what I see anyway coming down. But we just have to wait for this hearing to see whether this trial is actually going to be adjourned to April. Most likely it is going to be adjourned to April. So until then, we just have to wait for this opinion to come down from the Massachusetts Supreme Court, which is, again, most likely going to deny the appeal. And we'll be back to getting ready for the retrial of Karen Reed. Well, that's it for now. Please, if you haven't, subscribe, like, and we will see you next time.